Teenage District Court for County of Washington.
You may be seated.
I've not seen this.
Mr. Bloom is not present. Is there, on the Jeffrey Bloom matter, is there anything that we'll need to take care of before Mr.?
I have nothing here. Thank you.
I will just say for the record, I have talked to all three of my witnesses and instructed them that we are not going to discuss the fact that Mr. Bloom is currently incarcerated during the trial, and that I will not be asking him any questions to elicit that type of testimony. I don't have to speak to the defense either. I expect 2 exhibits, Your Honor.
Well, exhibits in terms of paper exhibit.
I have videos. I have 1 video, and I also have paper exhibits that are the victim's medical records.
Okay. And Springsteen, you've gotten both of those.
Yes, Your Honor.
All right. And you know, in terms of the video, you know what, I don't know how it's broken apart. You know what portion will be played?
There's a 10-minute long portion that shows some before interactions and then the alleged incident, and then it ends. It does not show the cell extraction. There are other videos that do, but I only intend to show the one that has the interaction.
Sounds good.
And you're aware of that, what video she's referring to. I just don't want to get into a circumstance where the video is being played and there's something in that portion
Schaumburg in the house.
that you or your client may object to.
No, I think it's fair
Hamburg-
game to show the video
Hamburg
of the
Flyers hat.
incident, and I think Ms. Lundy is not going to talk about anything after that point, so I'm sure she'll cut it off.
Okay, and we know, okay, I get you. I just want to make sure we know where it's cutting off.
I'd be happy to just show it to the defense counsel right now before we get started.
Okay. Why don't we do that?
It'll just take a moment.
Okay.
And then
Thank
we're
you.
not gonna talk about cell extraction. It's my plan. There was communication between the victim and the witness, a witness later, about how the victim had to go to the hospital to get treatment because he felt he had been injured. So that may be the only thing after the assault that gets spoken about, not the cell extraction itself.
Okay, everybody sent this to me, but I have to thank Alyssa, who actually went through and gave me the timestamp so I could edit it.
So, but that conversation occurred between Mr. Bloom and somebody?
No, Your Honor. It occurred between the victim. It is
Victim
likely
and-
not going to be admissible due to a hearsay issue. However, if it comes up later that, did you make anyone aware of your injuries? Yes, I told so and so. It comes up
Got
with
it.
that.
So it's a conversation that the victim has with someone else. Okay.
It may be a thing. I'm just saying, I don't wanna make a statement that nothing after the assault will come into evidence when it's possible that this conversation and the happenings of the victim receiving medical care may come in, and those did happen after. So
And just so that I'm clear,
I guess I should do 10 seconds of background. Jeffrey Bloom is a general pain in the backside. There have been a lot of videos about him. Hell, I may even have a playlist. I'm not sure, but he has enough videos for a playlist, and he's just goes and makes a nuisance of himself all the time. This is kind of interesting because I never knew what any of the underlying charges are, because he's just always in trouble, making crude gestures, just contempt, all the usual stuff. So now we're actually getting to a substantive trial for one of the things he's charged for.
and I just want to be clear on this because of this, that you're initially not trying to enter that, but there may be something that happens that causes that to be entered.
I intend to enter the fact that he received medical care.
Right.
And got his medical records. I do not intend to have the 2 jail employees discuss that went, just maybe something that comes.
Yeah, Ladybug, that's a better summary than mine.
in the course of cross-examination.
Got it.
This is going on super ultra speed.
But again, with that, if there is some dispute as to whether or not, and again, I don't know.
Well, they're just over at that point.
So I just showed Mr. Bernstein the entire 10-minute portion of it.
Yeah, that's correct, Your Honor.
All right, you're not going to have an objection to the admissibility of that document that you're aware of at this point.
No, Your Honor. Unless Ms. Landy like really drops the ball.
All right, yes. Okay, anything else?
My witnesses are sequestered,
Got it.
except for my officer in charge, Nick Aaron, so I know who's staying at the table with me.
Got it.
From the defense, Your Honor.
All right. Give me 2 minutes and then we'll be in and do this.
What's the name district court, county of Washington, state of Michigan,
You may be seated.
All right, the whole video is 5 hours. I cut a lot out because probably 3 hours of that was gaps.
I think we can bring Mr. Blue.
But I might need to Uber in some claws for this. I don't know if I can do this without at least a cocktail. I haven't seen him yet, but I know he shows up. There he is. He was waiting for my intro. Thanks, Jeff.
Court does call the case of the people of the state of Michigan versus Jeffrey Wayne Bloom. Counsel, state your appearances, please.
Good morning, Your Honor. Counsel, lobby of the people.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Bloom. Is present. All right.
All right. And date and time set for the
Yeah, Moonglow, that generally is frowned upon.
jury trial and the parties ready to proceed.
People are ready to proceed, Your Honor.
Yes, Your Honor.
All right. Let's bring the jury.
Oh, CHM, that's easy to do. They're cut from the same cloth. I if someone can find it for me, I'll post it in the description. But my favorite Jeff Bloom video is he couldn't behave himself. So they put him they put him back in his cell during a hearing, and he was just he was making every crude gesture you could imagine. It was like X-rated charades. I forgot about that. It was good times. I don't know where it is, but it's top notch.
May be seated. Your Honor, the jury.
Thank you. Court does call the case of the People of the State of Michigan versus Jeffrey Bloom. Counsel, state your appearance for the record. Thank you.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Bloom, who's present with me.
All right, thank you. Members of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I will now ask you to stand and swear to perform your duty to try this case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, you may instead affirm to try this case justly and to reach a true verdict. If each of you would please rise. You would raise your right hand. Do each of you solemnly swear or affirm that in the action now before this court, you will justly decide the questions submitted to you, that unless and until you are discharged by the court from further deliberation, you will render a true verdict, and that you will render your verdict only on the evidence introduced and in accordance with the instructions of this court. So help you God.
I do.
You may be seated. You will soon receive a written copy of the instructions I am going to read to you, or will receive them. You may refer to them during the trial if we provide you a copy of those. Since no one can predict the course of a trial, these instructions may change at the end of the trial or at the close of the trial. I will provide you, and at the close of the trial, I will provide you with a written copy of my final instructions for your use during deliberations. Ladies and gentlemen, I will now explain to you some of the legal principles you will need to know during this trial and the procedures that we will follow in this trial. The defendant in this case is charged with the crime of assault and/or assault and battery. To prove this charge, the people must prove all of the following elements beyond a reasonable doubt. First, as I said, the defendant is charged with the crime of assault and battery. First, the people must show that the defendant committed a battery upon a Rocky Isley. A battery is a forceful, violent, or offensive touching of a person or something closely connected with the person of another. The touching must have been intended by the defendant, that is not accidental, and it must have been against Rocky Isley's will. It does not matter whether the touching caused an injury. Second, that the defendant intended either to commit a battery upon Rocky Isley or to make Rocky Isley reasonably fear an immediate battery. A person accused of a crime is presumed to be innocent. This means you start with the presumption that the defendant is innocent. The presumption continues throughout the entire trial and entitles the defendant to a verdict of not guilty unless and until you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made of parts called elements. The prosecutor must prove each of these elements beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. A trial follows this procedure. First, the prosecutor makes an opening statement where she gives her theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make an opening statement after the prosecutor makes hers, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views this case. Next, the prosecutor will present her evidence. The prosecutor may call witnesses to testify, may show you exhibits like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of her evidence, the defendant's attorney may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of defense witnesses. After all of the evidence has been presented, the prosecutor and defendant's lawyer will make their closing arguments. Like opening statements, these are not evidence. They are only meant to help you understand the evidence and the way each side sees this case. You must base your verdict only on the evidence. My responsibilities as judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about the evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of this case. As jurors, you are the ones who will decide this case. Your responsibilities as jurors is to decide what the facts of this case are. This is your job and no one else's. You must think about all of the evidence and all of the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each witness has said. What you decide about any fact in this case is final. As indicated, part of your job is deciding what the facts of this case are and to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias, prejudice you may have based upon the witness's disability, race, national origin, ethnicity, gender identity, or sexual orientation, or that of religion, age, or socioeconomic status. There are no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or other personal interest in how this case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? When it is time for you to decide the case, you are only allowed to consider the evidence that has been admitted in this case. Evidence only includes the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I may tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think that something is true just because one of the lawyers asks a question that assumes or suggests that it is. I may ask questions myself of the witnesses. These questions are not meant to reflect my own opinions about the evidence. If I do ask a question, my only reason would be to ask about things that may not have been fully explored. If you cannot hear something that is said or presented, or if you cannot see a witness or the evidence, please raise your hand immediately.
See, we're learning here on Law Talk with Mike. If I have any law students in here, I want you to leave immediately so you don't get jaded.
During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I will rule on those objections according to the law. My rulings for or against one side or the other are not meant to reflect my own opinions about the facts in this case. Sometimes the lawyers and I will have to have discussions outside of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have nothing to do with this case. I respectfully request that you pay no attention to these interruptions. You must not discuss this case with anyone, including your family or friends. You must not even discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case amongst yourselves, but only in the jury room and only when all of the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected with this case. This means you may not speak with those individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part.
Hey now.
If someone tries to discuss the case with you or in your presence, tell them to stop, explain that you are a juror and not allowed to discuss the case. If they continue, you should leave and report the incident directly to me as soon as you return to court. When the trial is over, these restrictions will no longer apply. When the trial is over, you may, if you wish, discuss this case with anyone. If we take a recess and you are permitted to leave the building during the course of this trial, I ask and you are instructed not to read, listen to, or watch any news reports about this case. Under the law, under the law, the evidence you consider to decide this case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not meet these standards, they may give you incorrect or misleading information that might unfairly favor one side or the other. So to be fair to both sides, you must follow this instruction. I do not believe that it is desirable during this trial or helpful to you to take notes during this trial. If you take notes, you might not be able to give your full attention to the evidence. So I respectfully request that you not take notes while you are in the courtroom. As you can see, we have chosen a jury of 7. After you have heard all of the evidence in my instructions, we will draw a lot to decide which one of you will be dismissed to form a jury of 6. Possible penalty in this case should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix any penalty within the limits as prescribed by law. I may give you instructions during the trial. After the evidence has been presented, you will hear the lawyer's closing arguments. I will give you closing instructions about the rules of law that apply to this case. You should consider all of my instructions together as a connected series. Taken all together, they are the law that you must follow. After my instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means it must reflect the individual decision of each juror. Ladies and gentlemen, during this trial, it is important that you keep an open mind and not make a decision about anything in the case until it is time for you to go to the jury room to decide the case. You must not let bias, prejudice.
Real quick, I have to say thanks to Fancy Pants RN. She found the video on the thumbnail. It says crude expressions, but it's Wild Court Moments number 202. Link in the description. It's good vintage Jeff Bloom.
Prejudice, public opinion influence your decision. Each of us may have biases or perceptions about other people based upon stereotypes. We may be aware of some of our biases, even though we do not express them. We may not be fully aware of other biases. Take the time you need to test what might be automatic or instinctive judgments and to carefully reflect about the evidence. I caution you.
Oh, good Lord. We have to like get indoctrinated with this bias nonsense in CLE constantly. Again, if there are any law students left here, get out. Get out before you figure out what you're walking into.
Again, avoid reaching any conclusions that may be unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually. But you should do so only after listening to and considering the opinions of the other jurors who may have different backgrounds and perspectives. Slandy, opening statement.
Thank you, Your Honor.
Good morning, members of the jury. We're here today, and I intend to produce evidence to show you that on May 30th of 2023, so last year, the defendant, Jeffrey Bloom, while being incarcerated at the Washtenaw County Jail, requested medical attention. He made it known that he felt he needed to have a medical professional come and evaluate him. Officer Navin, he asked Rocky Isley, a nurse, to come and look at this person. When Rocky came to evaluate the defendant, the evidence will show that Rocky deemed it necessary to check his vital signs. As a nurse, Rocky then touched the defendant's arm and took his blood pressure with a blood pressure cuff. I believe the evidence will then show that the defendant ripped his arm through that food slot while Rocky Isley was still holding on to it, slamming Rocky Isley into the metal cell door. I believe the evidence will then show
Nasty. This is worse than I thought, actually.
that Rocky went to get medical attention later that day. The evidence I also believe will show that Rocky worked overnight. So he didn't get to go to the doctor until the 31st, but this did happen on May the 30th. At the end of the evidence, I will be asking you to return a verdict of guilty of assault and battery for the defendant. Thank you.
Thank you. Mr. Bernstein, would you like to give an opening statement now? Reserve.
What an a-hole. I would have closed with what an a-hole. Might have gotten in trouble for that, but I don't know how else I could have left without saying that first.
Or wait.
I'll go now. Thank you.
Very good. Proceed.
Being in jail, the way Jeff was, is stressful, it's difficult, it's rough. And where Jeff was staying specifically in the jail was more difficult than normal jail. He was isolated. He couldn't leave but for an hour a day. And when he left, it was in handcuffs. He couldn't shower. Often he wasn't able to shower 4 or 5 days at a time. And this took a toll on him physically, with his skin, with his hairs, getting skin lesions. It's not easy time. And this wears on you day after day, week after week. He was doing 7 months in that situation. And it gets to you physically, it gets to you mentally. Being told on this day that he couldn't come out and shower, that you don't get to shower today, continues to eat at Jeff. And just the inability to do basic human things is wearing at him. He's complaining of chest pains, and Rocky Isley shows up to evaluate him, and Jeff says, "I don't want you here." Tell him he doesn't want him there to evaluate him. Doesn't trust him, and Rocky has to convince him to let him take the vitals. Okay. The situation, all this time, the agitation, the distress, the health problems, the mental anguish, it comes to a head in this encounter with Rocky. And following that encounter, decisions get made. Decisions to turn this into something that it's not. And those decisions have very real consequences for Jeff.
Can we approach?
Come in. Sir, please come forward and be sworn.
See, you raise your right hand. You solemnly swear to affirm the testimony you're about to give with the truth, whole truth, and nothing but the truth, so help you God. State and spell your first and last name for the record, please.
There you go, ladies. You got your bailiff fix.
Nicholas Maven, Nicholasnavan.
You may inquire.
Sir, how are you employed?
I'm employed through Washington County Sheriff's Office, currently adjourned.
And how were you employed in May of 2023?
Officer.
And a corrections officer, where does that mean you work?
I work in Washington.
Do you recall the date of May the 30th, 2023?
I do.
Did you have direct contact with anybody in the Washtenaw County Jail who's currently in this courtroom on that date? Who was that?
Mr. Jeffrey Bloom.
Could you please identify him by an article of clothing he's wearing and where he's seated?
Yes, he is seated over here with a white shirt.
Your Honor, may the record reflect the witness identify the defendant?
That objection, record just so reflect.
Where were you assigned to work that day?
I was assigned to work the afternoon shift in the A max ops area of the jail.
The AMAX, what was the last word?
A max ops observation.
All right, we got an extra bailiff in there I never see, but he looks like he's ready to whoop some ass too. I think they're ready for Mr. Bloom.
And what is that area?
So it houses several different inmates. It could be for disciplinary issues, detox. They have housing for maximum security inmates, suicide precaution inmates, and also protected custody inmates.
How many inmates to a cell in this area?
So in the A block area, it's 1 man cell, as well as the max area, and the observation area can hold up to 4 inmates per cell.
What type of cell was the defendant in on that day?
So the defendant was in 1 max cell, which is the max area, which is a single person cell.
Do you recall what shift you were working on that day?
Yes, I was working the afternoon shift, which is 3 in the afternoon, so 11 o'clock at night.
Did you have any interactions with the defendant during that day?
I did.
What were your interactions like towards the beginning of your shift?
The beginning of the shift was just immediately met with agitation from the previous shift, disrespect.
Did you know why the defendant was irritated?
I had to do something with the previous officer on the previous shift. I'm not 100% sure, but I was told that.
I'm going to object, Your Honor. I think the answer to what I was told would be hearsay.
Well, he can give his understanding, to the extent that it revolves around his understanding of why. That goes to his state of mind. Objections overruled. Continue.
What was your understanding?
So my understanding that on the previous shift, Mr. Bloom was being very agitated and disrespectful to the officer on shift. And Mr. Bloom was given the option for his outside that day in the morning, which per our captain, level 1 inmates, which Mr. Bloom was at the time, were to come out first thing in the morning. And during my time, I worked from 3 to 11.
Did the defendant tell you that he wanted to come out during your shift?
He did.
And what did you say?
I told him due to his previous actions and due to the order given from our captain that he was unable to.
Did you have other interactions with the defendant during your shift on that day?
I had a few passing moments, yes.
What are some of the duties that you are responsible for when you're working in that part of the jail?
So that part of the jail, my biggest thing is keeping up on my wellness checks. I do it mostly about every 15 minutes.
What's a wellness check?
It's walking cell to cell to make sure everyone is accounted for, breathing healthy, and not under any duress, and to address any needs that the inmate must need.
Did the defendant indicate any needs to you?
He indicated at around 10 o'clock that he would experience a chest pains.
What did you do?
I immediately radioed to our medical staff on staff and advised on the situation.
At that time, did the jail have in-house medical staff? What happened after you radioed to medical staff when the defendant told you he was having chest pains?
So shortly after, Nurse Rodney came down to the unit to evaluate Mr. Bloom. And as soon as I reached the food slot to the cell door, Mr. Bloom immediately stopped his arm and was screaming expletives and saying he was in fear for his life.
Now, not everyone may be familiar with what a food slot looks like in a jail cell and frankly, what this jail cell looks like. Can you describe how these jail cells look? Do they have bars? Do they have something else?
Sure, so the cell is comprised, the outside cell is comprised of a door which has to be reached by either our central control or a key, and the cell is a single bunk with a sink and toilet and mirror.
You say breached, is there like opened basically? Okay. Now the door, is there anything besides the door on the front of the cell?
There is a food spot that can keep open to pass food, how we refer to the food spot. It can food, medications, or anything else that needs to be handed through the door without actually breaching the door.
Where is it located on the door relative to the ground? How high up?
I'd say it's about thigh high, I'd say.
So when Nurse Rocky arrived and you opened the food slot, you said the defendant stuck his arm out?
Correct. He stuck his, I believe it was his left arm outside the slot and was refusing to let Rocky do a medical evaluation. He was screaming and could not even reason.
What happened next?
So that's when I asked him multiple times if he would like to have his vitals checked, which he did not respond to, kept on screaming. So then I decided to terminate the interaction and continue to pass medication through A block. However, so after that, I decided to go back again and check to see if he was vitals checked.
Did he?
He did. I went to his door and he started screaming again that he was in fear for his life when he went up to an officer. And in order to de-escalate the situation, that's when I used my radio to call for an additional officer, which ended up being Officer Tweedell, to stand by during the evaluation.
Once Officer Tweedell arrived, did anyone else come?
No, the only ones that were in the situation were myself, Officer Tweedell, and Nurse Rocky.
What happened next?
So once Officer Tweedell arrived on scene, Mr. Bloom kept on screaming and could not get a word in. That's when Officer Tweedell was able to reason with him to let Rocky do the evaluation through the food slot so we can get things going. And that's when Mr. Bloom complied to have his arm through the food slot and have the blood pressure cuff put on his arms.
Why not go into the cell to do the evaluation with Nurse Rocky?
So Mr. Bloom was highly agitated, and as stated before, Mr. Bloom, it was a level 1 inmate. A level 1 inmate, when the door is breached, they have to have handcuffs and leg irons placed on. Due to Mr. Bloom's level of anger at the time, my duty sergeant, Sergeant Greg, I was informed to do the evaluation through the food slot.
Now, once Officer Tweedell, it's officer, right? Officer Tweedell? Thank you. Once Officer Tweedell was able to speak to the defendant and start the evaluation, what happened next?
So once we were able to finally get the blood pressure cuff on him, that's when Mr. Bloom swiftly pulled his arm back into the food slot, back into the cell, taking the blood pressure cuff with him.
Did you see that happen?
I did. I tried to retrieve it back, but was unable to.
I missed the Netherlands already, by the way.
Did you see what happened with Rocky specifically, Nurse Rocky?
I was not, my attention was mostly on Mr. Bloom. My attention was not on Nurse Rocky.
When you're at the door Is there anywhere to look inside of the cell besides an open food slot?
So the cell door itself is opaque, but there are transparent windows if I would enable myself differently.
And where were you paying attention when this happened?
I was mostly looking towards the food slot with Mr. Bloom's arm outside of the food slot and just trying to make sure that everything, he didn't try anything.
Are you aware if there are cameras in the jail? Are you aware if there was a video recorded that showed part of this incident?
I-
Have you reviewed that video today?
Yes, I have.
Your Honor, may I approach the witness?
You may.
Mr. Navin, I'm going to be approaching you with what's been marked as People's Proposed Exhibit 1. What do you recognize that to be?
I think we do get some
This
video
is
here.
a CD or DVD.
And what does it have on it?
Bloom videos, also a red sticker, so you can put one as well as my initials and Officer Tweedale's initials.
Is that a video, is that a disc that contains the video from this incident?
Yes, it is.
Is it a fair and accurate copy of the video?
I think so.
And I move for the admission of People's Proposed Exhibit 1.
Any objection or what here?
No objection, Your Honor.
Exhibit 1 is admitted.
Permission to approach to the jury?
Yes.
Permission to approach the witness?
Yes.
Apologize, I cannot make this window any bigger when it comes up, Your Honor, so
All right.
there's a limitation of the system.
Number one, know what I'm saying? Number one, know what I'm saying? We are the law talk with my crew. Number one, know what I'm saying? Number one, know what I'm saying?
It should be coming up on the screen whenever it is switched over. Officer Navin, are you able to see that video on the screen that's sort of at your stand?
Yes.
Can you please tell the jury, I have my pointer here, if you are able to see that moving on the screen. This door here in the middle of the video, what's that?
That is the cell door for cell 3 MX in the max area.
And which cell was the defendant in, if you
He was
recall?
in 1 MX, which is more towards the upper left.
Now I'm using my pointer to sort of indicate over here. Is that correct? For the record, this is a 10-minute video. I don't think there's any objection from defense counsel if I skip ahead just a little bit.
No objection.
Fast
All right,
forward.
very
just a bit. Who's that on the video that we see now, that person?
That's all.
What is that thing that we see at the door?
That is Mr. Bloom's arm outside of the food slot.
This is pretty gripping stuff, huh? Is it playing?
Officer, as far as you're aware, is there audio recording with these cameras? 22:30, I'm going to fast forward again just a bit.
Yeah, let's get to the money shot, huh?
At 22:24:06, a person comes into view. Who's that?
That's Officer Trudell,
And who's the other person?
and that's me.
Who's that third person we see now?
That is Nurse Rocky.
Okay, I apologize. At least on Ricada, you do get a money shot.
Ma'am, are you a whore? You're not a whore? Not a whore? You're not a whore? I never want to hear it again.
This helps. I don't care what anyone says.
Not a whore? You're not a whore? I never want to hear it again. It gets worse.
There were drugs involved that were given to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack.
Let's go.
You didn't say the cat jumped on his wiener, did you? Sit down and shut up. Shut up. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up. Cat jumped on his wiener. Cat jumped on his wiener. Shut up.
Can you just let this go for once? For once? Once?
Okay, that didn't go.
Pass here, Your Honor, at 22:27 and 2 seconds. Officer Navin, was that the incident that you had described to us a few moments ago, captured on video?
Yes, it was.
We have a moment, Your Honor.
Yes, you may.
They almost boinked heads, which this video needs.
I'll pass the witness, Your Honor.
Cross-examination.
You went to the cell and you asked Jeff if Rocky could take his vitals, right?
Correct.
And you talked about you had to ask him several times,
Correct.
and he was screaming uncontrollably.
Correct.
I think you said he was agitated.
Correct.
But you still tried to get him to agree to let Rocky take his vitals, right?
Correct.
And I think there was eventually, I guess, an agreement to get another officer that would be available to be there. So you saw the video, you're right up close to the cell. And
That's a yes.
Yes.
Thank you.
Jeff's arm is out the food slot.
Yes.
Rocky is like right in front of you.
Yes.
Officer Tweedell is on the other side of Rocky.
Yes.
You guys are really close together. Maybe like a foot, 2 feet away from each other. Okay. You did not see Jeff grab Rocky,
Correct.
right? That was not something that was a part of this. Jeff did not grab Rocky.
I did not see Mr. Bloom grab Rocky, no.
You did not see Rocky's body hit the cell door.
I did not.
So that was also part of this interaction, was you did not see Rocky's body hit the cell door, right? We watched the video from a camera angle. There's more than one camera in that hallway, right?
I believe so, yes.
There's a camera that points right at Jeff's cell door,
I believe so, yes.
and that would have been in the upper left-hand portion of the hallway, like if I'm looking at the video.
Correct.
We don't have that video here today, right?
Right.
We only have the video that you showed. You would agree with me that the video right in front of that door would have been helpful for us.
Correct.
In the video that we watched, that video did not show Jeff pulling his arm back.
Correct.
That video did not show Rocky being pulled.
Correct.
And again, you did not see Jeff grab Rocky or Rocky touch the door, right?
Correct.
Thank you, officer.
Any redirect?
Officer, are you allowed to ignore a medical emergency or any potential medical emergency for?
No, every medical emergency, whether it be true or untrue, or just take it very seriously.
Why?
Just in case that actually something is happening. Can't respond to one thing and not respond to another thing, pick and choose.
How fast did this happen?
The full incident took, I'd say about 20 minutes, 15, 20 minutes.
Let me ask a better question. How fast did it happen when the defendant pulled his arm back in the cell and you shut the door? Less than a second?
Yeah, I'd say maybe a second, less than a second.
Officer, in the video we watched, would you agree that you're sort of blocking the view of the camera to look at Jeff and Rocky touching each other, interacting?
I would say Officer Tweedell is mostly covering that portion up.
I apologize, Officer Tweedell.
Yep, Officer Tweedell is definitely covering that portion. That would be, that would have the food slot and the camera, yes.
May I have a moment, Your Honor?
You may.
Thanks. Thank you. Your Honor. Nothing further.
All right.
Excuse me.
Yes, you may step down, sir. This witness may be excused unless there's an objection.
No objection, Your Honor. Thank
All
you.
right, thank you. Thank you, sir. You may call your next witness.
Attorney did a nice job poking holes in the state's case there. The video was not great, based primarily on angle, and then he drops in there that there's a closer camera. I'm actually kind of surprised they allowed that, but that's okay. And now we're all thinking, did anything happen? Which is really good for the defense. Presumably, she's going to get up there. Is it a she? Whatever, the nurse, be it a man or a woman, is going to get up there and say it happened and describe it.
Please come forward, be sworn. Go ahead.
Before you take a seat, raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So we got. See, state and spell your first and last name.
Rocky R. Isley, R-O-C-K-Y, last name Isley, I-S-E-L-Y.
You may inquire.
Good afternoon, Mr. Isley. How were you employed in May of 2023?
I'm with a correctional nurse in the jail.
What jail is that?
The Washington,
Where is that located?
downstairs from this building,
Do you know the address for the jail?
2201 Hogback Road,
What township is that in?
Washington County,
Washtenaw County, what state?
Michigan.
Thank you. And how long had you been working in the jail at the time of this incident in May of 2023?
I started in August of 2021.
Now, on May 30th of 2023, did you have direct contact with someone in the jail who's currently in this courtroom?
I did.
Who's that?
Mr. Bloom,
Do you recognize the person you know to be Mr. Bloom in the courtroom?
I do.
Can you please tell me what he's wearing and where he's sitting?
He says that the defendant's stable. He's wearing a white shirt.
Your Honor, may the record reflect the witness identify the defendant?
That objection, record shall so reflect.
Now, what happened where you came to interact with the defendant on May 30th of 2023?
I was the night nurse on that day. I was currently out doing my evening medication pass. I believe I was on C block in the front of the jail. I was responsible for passing meds in the front of the jail. While on that block, they came across the radio that there was an emergency response to A block. So I responded to A block.
Were you the only nurse working that night?
There was two nurses.
But you were the one who needed to respond?
Yes, I was the closest, and that was the front part of the jail where A block is located is my responsibility.
What happened when you got to A block?
The officer, within A block, that officer is also responsible for two smaller sections, which is considered max and ops. They're just smaller little blocks. And he informed me that Mr. Bloom, that was housed in max, was complaining of chest pains.
How long have you been a nurse?
Since December of 2009.
And you are an LPN or an RN?
I'm an LPN.
When someone is complaining of chest pain, you as a nurse, what is the first couple of things, the first thing that you want to do?
Well, initially you do a visual assessment, and then I would, automatically I would want to take his vital signs, him or her vital signs.
Now, when you do a visual assessment, were you able to do that while the cell door remained closed?
I was.
Through where? How were you able to do it?
There's a window right there next to the cell door.
After you completed your visual assessment, what happened next?
I was gonna take his vital signs, but the officer, Mr. Bloom, was agitated when he saw me arrive, and did not want me to be the one to assess him. So he was already agitated in front of the window.
Did he say anything to you?
Not directly to me, he was just stating that he didn't want me to assess him, he didn't trust me, other, disparaging type things.
Did he have a reason not to trust you?
I have no idea why he would have no reason to not trust me.
So as you came closer to the cell, or as you were standing there, what happened next?
The officer then made the decision, because of his level of agitation, that, he was gonna call another officer there just to stand by so they could, open the cell door and I could take his vital signs and, assess it.
Now, when you say open the cell door, can you be more specific about what was opened or how this medical evaluation was going to take place?
Well, from my understanding, his custody level, that and because of his level of agitation, they would actually have to physically open the door so I could go into the cell and assess it.
Is that what happened?
That is not that.
What happened?
By the time the second officer had arrived, the officer that actually was on that block, made the determination that it probably would not be safe to open the door, even with there being two nurses there. So they requested that I take his vital signs through what they call a food slot or a bean slot.
A bean slot?
Yeah, it's a small, it's the door, it's about thigh level that slides down, and that's where they pass their food trays and things through.
Now, you said a moment ago there were two nurses present. Is that correct? Or I want to make sure I understand your
I
testimony.
was the only nurse, but there's two officers.
Oh, two officers.
Another officer to stand by.
Very good. Thank you. So that was the determination to happen through the food slot. What happened next?
So that was the only way that I was going to be able to get his vital signs. So he put his arm through the slot, and like I said, it's about thigh level. So I had to kind of crouch down a little bit, put the blood pressure cuff on, and put the stethoscope on, and have to look at the gauge. And so as I was pumping up the blood pressure cuff to get his blood pressure, he suddenly just jerked his arm inside back inside the bean slot. But while I had the cuff on, it's a spot that's about that.
So you're using your hands to demonstrate a distance. To me, that looks like
the bean slot's about that wide. So when his arm was through there, I put the cuff on. I had my right arm underneath, kind of supporting his arm while I was pumping up the blood pressure cuff.
Why would you do that? Why would you put your arm underneath his arm to support it?
Just for comfort and so the cuff, to get a proper reading, I can cuff my hand like this. If it was just laying flat on the bottom of the slot, I wouldn't probably get an accurate blood pressure reading from it. So supporting his arm like this, and when he pulled his arm in, my hand was actually underneath the blood pressure cuff. So the force of that coming back into his cell kind of jerked me forward. And I was on an angle because I was looking at the gauge. So when that happened, my arm went into the slot with him, and I jerked forward, and the side of my head hit the cell door.
How fast did that happen?
Just in a few seconds.
Okay. When this was going on and you were taking his vital signs, I'm sure many people have been to the doctor, if not everybody, or the nurse or something. What are the vital signs that you're going to take to evaluate if somebody's chest pains might be a medical emergency?
Just if his blood pressure was, dangerously elevated, I hadn't even gotten a chance to take his pulse or anything like that. Now, based on the blood pressure and if I had gotten his pulse, it's O2 and his heart rate, then, that would have directed me more towards, if I actually had the request from the officers, maybe that, whatever their policy is, to probably get more officers or whatever we need to do, so I could have actually physically gone in and assessed him. Put the stethoscope, get heart sounds, things like that.
So when you came to the
Okay, I haven't seen this, and I don't know where it goes, but we're leaving open a good argument on intent here. So he's not saying he grabbed him. He's saying he just jerked his arm back, and the force of that pulled him forward. And the statute says you got to intend to cause harm. So that's where we are. This is interesting.
door and you were performing your medical evaluation and it came time for you to touch the defendant to perform the blood pressure check. Did you consent to touching him in that way to do a medical evaluation?
Did I consent?
Yeah. Did you feel good about making contact with him? You felt you consented to that?
Yeah.
And he consented to your touch to him?
Put his arm out the slot. I was putting the blood pressure
Hey, now.
on. He was, complaining of chest pain, so.
Mutually consenting adults here.
And he agreed to let you do that? Did you agree to have your arms pulled inside the cell and be slammed into the cell door?
I did not.
Yeah, that's where he drew the line.
Now, after that happened, we're not going to talk about a bunch, but did you ever seek medical care?
I'm making fun, but that's absolutely appropriate of the prosecutor. You want to establish exactly that for the argument she needs to make.
When it initially happened, they asked me if I was all right. I was, I was jarred by it.
And only talking about what happened to you, how did you feel later?
Approximately an hour after it happened, I started feeling that I had a kink in the side of my neck. So I reported that to the duty sergeant, and he then, I guess, contacted the lieutenant, and they then informed me that the jail wanted me to go and be evaluated at the hospital.
Did you do that?
I did.
Which hospital did you go to?
St. Joe's, Trinity Health.
Yeah, everybody keeps calling it St. Joe's. It was St. Joe's, now Trinity Health. Is that correct?
That's right.
Did you get a copy of your medical records and give them over to law enforcement in my office for this case?
I didn't personally get them. I believe that they were requested.
Sent over, released?
Released.
Yeah.
I mean, I did release it.
Yeah.
But I
And-
just,
Did you have a chance to review those medical records this morning?
I did.
And understanding there may be some other things in them, did you have a chance to look at them and see that they were the ones from this case? Your Honor, may I approach with People's Proposed Exhibit 2? And I have a copy for defense as well.
Your Honor, I have no objection.
To the admission of Exhibit 2.
Yes, Your Honor.
Exhibit 2 is admitted.
Thank you. Mr. Isley, I just want to talk about a few things. I believe you communicated there were a couple of inaccuracies in these records. I wanted to talk about those. Which parts did you notice that were inaccurate on the first part?
It says that I work in prison, actually it's jail. And then it says it said prison bars, like instead of the bean spot, there wasn't prison bars.
Okay. But as far as your vital signs, as you recall, your symptoms, everything else in here was accurate?
Yeah.
Did you receive any radiology tests?
No.
Did you have an X-ray?
I believe they did an X-ray.
If I can direct your attention to page 3. Medical decision-making. Does that indicate that you may have had an X-ray on that date? And what does it say?
that, was negative for a fracture or other acute abnormalities.
And what were you, what was sort of the decision that the physicians made about your medical status at the time of this evaluation?
That was, like a sprain. I sprained the muscle in my neck.
All right. May I have a moment, Your Honor?
You may.
I have no further questions. May I approach the witness to retrieve Exhibit 2 and publish it to the jury?
Yes, you may.
I will pass the witness at this time, Your Honor.
Cross-examination.
Your Honor. Mr. Isley, before we get into the meat of it, I want to acknowledge some things about your job. So you work in the jail here, right?
That's correct.
That's like one of your main duties, or that is your main duty?
As a nurse, yes.
Okay. And I'm guessing working in a jail isn't the easiest medical job that you could have gotten, right?
That's correct.
Not some cozy urgent care where people come in with like poison ivy and stuff like that.
I would agree.
There's a different specific population there,
I do love a cozy urgent care, now that you mention it.
right?
Yes.
People might be agitated when you see them. Is that fair to say sometimes?
Okay.
You could meet people that are difficult to deal with, right?
Yes.
Sometimes, I'm not talking about Jeff, but there could be people with like mental challenges, things like that.
Oh, I think that applies to your client.
Okay, so you're radioed to go see Jeff on a complaint of chest pains.
Right.
And you, of course, go to see him. Jeff is, well, I don't want to say an older gentleman, but he was like 57 at the time.
I mean, I don't know what his age is, but that's.
Okay. Well, I guess someone being closer around 60, you might pay more attention if they're complaining of chest pains.
I don't determine their age. I mean, if I treat saying chest pain is chest pain.
No, I'm not saying that you need to determine their age. I just meant, would you be more concerned if someone's complaining of chest pains and they're, older than a 23-year-old?
Not really necessarily. I mean, I treat chest pain, there's young people that, that have chest pains also. I mean, that's not for me to determine.
Jeff is agitated when you get there?
Yes.
He's yelling when you get there?
Yes.
He doesn't want you to see him, at least at first. He has to be convinced to see you.
Well, I told him that, that I was the nurse that responded. I mean, I'm here, you're complaining of chest pains, if it's truly chest pains, and I'm here to evaluate while I'm the nurse.
Sure. And so there was a request that there be a second officer with you.
Yes, the first officer requested that another officer respond.
When someone's agitated like that, could they have higher blood pressure?
Definitely. I mean, their agitation is raise the blood pressure.
Okay. And someone like yelling and screaming, that could be a high blood pressure situation.
Yes.
You make the determination to take Jeff's blood pressure, right?
Yes.
And you wrap the blood pressure cuff around his arm.
Right.
And after wrapping the blood pressure cuff, you then touch his arm, right?
I put this hand underneath the cuff, cupped it So when I, inflated it, you know, it wasn't sitting flat on the bottom of the bean slot, which, you know, could put pressure on it to deflate it so I wouldn't get an accurate, blood pressure.
Then your fingers touched his skin?
No. My hand was cupping the cuff that was already on his arm.
Okay. So your hand is touching the cuff that's around his arm?
Right.
Okay. And he's sticking his arm out a food slot.
Right.
And this is thigh high off of the ground. So, okay, so he's like bent over to get his arm out.
Right. So am I.
So are you.
Back up.
And so what he's like this. It's like kind of an awkward position.
Correct.
Okay. So he's got an awkward position, sticking his arm out, and then you are touching the blood pressure cuff that's around his arm, right?
Right.
And that's when his arm pulls back.
Yeah,
Just pulls his arm back.
pull his arm back.
Okay. After you left the jail, you went to the doctor's office. Right.
Sorry, can you repeat that?
After later on, you went to a doctor the next day,
No.
the next morning or something.
That,
No,
that I should really go with that for a
this
title.
happened, like in the middle of the that, so it was probably 9 o'clock or so. So,
At night?
yes, I work a night shift from 6 at night until 6 in the morning. So about an hour after the incident is when I felt that tightness in my neck. I reported that to the duty sergeant. And then, within a half an hour, he had communicated with the lieutenant.
Who's the lieutenant?
I believe it was Lieutenant Arnett,
Okay.
who was in charge of, I guess that's,
So Lieutenant Arnett told that person to tell you to go to the doctors?
that I needed to go to the hospital and be evaluated.
But at the time that Jeff pulls his arm back, you're not like in pain, you're not noticing anything that's a problem, right?
I mean, not in my head. Yeah, it hurt, but, I still had pretty much my entire shift left to complete.
And so you need to finish your duties in the jail, so you keep going on, right? Okay. When you go to the doctors, you talk to a doctor there, right?
Well, with the hospital, yes,
When you go to the hospital, you talk to a doctor there, right?
correct.
You tell a doctor that an inmate grabbed your arm and pulled back?
I told him that I was assaulted at the jail.
Would it help refresh your memory to look at the medical records to see what the doctor wrote down?
Sure.
Judge, could I approach?
You may.
Okay, yep.
Okay, I'm just gonna snatch that. So you would agree with me that what you said to the doctor, an inmate grabbed his arm and pulled back? Right?
Yeah.
Agreed. This is professional all
But
around.
that's not your testimony today. I mean, what you said happened was that Jeff pulls his arm back with the blood pressure cuff on it. Right?
Objection. Oh, sorry.
Well,
An objection?
I was gonna be informed of the question because there wasn't a question.
Okay, got it. Okay, that's fine. Go
isn't
ahead.
it true that you testified earlier that Jeff pulls his arm back with the blood pressure cuff on it?
Yes.
Your testimony here is not that Jeff grabbed your arm, but it said he pulls his arm back with the blood pressure cuff on it. That's what your testimony is?
He grabbed my arm?
Your testimony on the stand, right? And, you know, what you're telling officers and stuff is that Jeff pulls his arm back with the blood pressure cuff on it. Okay. I have no more questions. Thank you, Your Honor. Thank you, Mr. President.
You redirect.
Mr. Honor. Nurse Isley, did you write this document? Your medical records? Somebody else wrote it, right? Did you in fact write an email documenting what happened?
I did.
And would reviewing that email actually would that refresh your recollection? Is that email something you wrote at the time that this happened?
Yes, ma'am.
And Your Honor, I'm going to approach with something I don't intend to do as an exhibit.
You don't intend it to be?
Unless defense counsel will stipulate this is in fact a copy of the email that was written.
That's not a proper exhibit.
Okay.
Well, whose email is it?
It's the victim's. It's his statement about what happened. I'm going to ask him to review it as a writing that he made at the time of this incident, documenting what happened on that day to rehabilitate him.
Well,
after the attack on his credibility.
I understand your rationale.
Yes.
But, and you want to admit that as an exhibit?
Yes, Your Honor.
And your objection to the exhibit is what?
Yes, Your Honor, I'm going to object to it. He's here to testify. He's given a narrative several times. He can use this to refresh his recollection, I would say. But beyond that, I mean, this is something that shouldn't be published to a jury. I mean, he could.
Well, but counsel, you were the one that opened the door to it, or through the questioning, opened the door to it by indicating that he made, or at least trying to say that he made a contradictory statement to medical personnel.
That's fair. I guess he did make a contradictory statement.
Well, I don't know whether he did or not. You're saying that he did. And so the people ought to be able to rehabilitate him if that's through an email that he wrote contemporaneous with the events, then I'm going to let that happen.
Thank you, Your Honor.
So exhibit 3 is admitted.
Thank you. Aaron, may I approach with exhibit 3?
Yes, you may.
I mean, I know it's boring, but all of that was reasonable and made sense, including his objection and the judge overruling it.
And I'll make a clean copy for the jury to disregard what's on the back in a few moments, but I'll approach with this now. Mr. Isley, do you recognize that to be the text of the email that you sent to the sergeant on May 31st, 2023, after this happened? Okay. Direct your attention down, halfway down, about halfway down on that, there's a sentence that starts, I, parenthesis, Rocky R. Isley, LPN, and parenthesis, applied the blood pressure cuff. Do you see that sentence?
Yes, ma'am.
And can you please read that sentence in its entirety for the jury?
I, Rocky R. Isley, LPN, applied the blood pressure cuff. And while beginning to inflate the blood pressure cuff and supporting his left arm with my hand, Mr. Bloom forcefully pulled his arm.
I think he's a decent witness, but the way he's reading this is cracking me up. It's like he's reading it like in a mad voice.
His blood pressure cuff back into his cell. Due to the quickness and forcefulness of this action, the right side of my head, shoulder, and neck kick his cell door.
Thank you. May I have a moment, Your Honor?
You may.
Nothing further in.
Thank you.
Direct, Your Honor.
And
So when did you write this email, Mr. Isley?
The day after the happened,
Okay. And did you write this before you went to the doctor's office?
before I went to the hospital, no.
You wrote this after the hospital? So we discussed earlier that when you went to the hospital, there were statements about an inmate grabbing your arm, right?
I'm gonna object again.
Sustained. Sustained.
You spoke with a doctor at the hospital, right?
I did.
And you made statements to that doctor.
Yes.
And you reviewed those statements here in court today.
Yes.
And we have an email that we just reviewed, right?
Yes.
And that email does not say that an inmate grabbed your arm.
Don't know.
So you would agree with me that this email is different than what's on your medical records?
Object again.
Sustained.
I have no more questions. Thank you.
There's nothing further from this witness evening, please.
I like it. I
So you
like
may
it a lot.
step down. Thank you. Any objection to the excusing this witness?
Oh, I have none, Your Honor.
All right, very good. We're going to take a brief recess. Can you take the jury? You have another witness?
I do have one more.
All right, let's take the jury.
All rise for the jury.
It's my understanding he eventually blows up.
I think with that voice, they'll get it right. You may be seated. All right. What I will do is, why don't we take about a 15-minute break, come shortly after 1. Let me try to take care of some other matters I have to take care of. Let me ask this, any objections to the introductory jury instructions as given?
No, Your Honor.
The only thing, Your Honor, I don't mind them taking notes. I don't know if that's like a court specific thing, but I wouldn't mind if they wanted to take notes, that's all. Because the court indicated that the court.
What does that mean? I I get in trouble for saying this, but you kind of sound like a chick there.
I would not let them take.
Yeah, I wouldn't think it
Sure.
was.
And I think
I have no
that's within
objection
the
to that.
court's discretion to do.
I agree. I do think it's within the court's discretion. The court gets to choose, so I have no objection.
Oh, I'm not arguing what's within the court discretion. I'm saying I don't mind personally if they want to take notes. That's all.
And if I decided that in my decision, I would have asked, but thank you. All right. He can go back and court's gonna stand in recess. We'll come back about, why don't we say 10 after?
Yes, Your Honor.
All right.
14A District Court for County of Washington, State of Michigan, is now back in session. The Honorable Judge J. Simpson preside.
You may be seated.
All right.
All right. Can we bring him?
I'm not sure, but I think it's about to get real in here. You know, Jeff Bloom cannot get through this whole hearing without acting up.
Any objection? All objections.
Does recall the case, People State of Michigan versus Jeff Wayne Bloom. Counsel, state your fear.
Actually, let me-
All right. We ready to continue?
please state your name for the record, ma'am?
He's not.
Okay, thank you.
Thank you. Lundy, you may continue.
Hey, John, the people call Tyler Tweedle. It's Tweedale, so.
Sir, please come forward and be sworn.
Please raise your right hand. You solemnly swear testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. I do. Welcome to your seat. State, spell your first and last name for the record.
Tyler Tweedale, Tyler, Tweedale, Twdale.
You may inquire.
Good afternoon, officer. How are you currently employed? And were you employed in that capacity in May of 2023?
Yes,
ma'am. And we've heard a little bit about, were you involved in an incident with the defendant on that date?
Yes, I was.
Who's that person to you?
Mr. Jeffrey.
Do you see the person you know to be Jeffrey Bloom in the courtroom? Can you tell me where he is sitting and what he is wearing, please? Your Honor, may the record reflect the witness identify the defendant?
Without objection, record shall so reflect.
How did you come to be at Mr. Bloom's cell that evening?
Well, Officer Nicholas Name was the primary officer. I was working at the unit, and Officer Name called for another officer standing by for a medical emergency. So I assisted with stepping down.
And when you arrived, what did you do?
So I kind of agreed to the situation. This exaggerated. He was kind of stuff like that. I Mr. Bloom, I got a report from my doctor, and he said he was having a medical emergency heart attack. So I kind of got him to follow on with the process to be evaluated by medical staff.
And to be evaluated by medical staff, what does that include?
So usually we open the slide door to be evaluated by medical staff, blood pressure, pulse ox, everything like that. However, with this level 1 status, we had to do it in the spot.
And what otherwise how would you choose to do it if not on a level 1 status?
Oh, yeah. So we'll just stand by one officer, pop the door open, reach it, have them sit down on the bed, medical staff will assess them, and go from there.
What medical staff was present for this?
Staff Rocky.
And do you know Nurse Rocky?
I did, yes.
Have you worked with him before this night? And when he was there and after you had called Mr. Bloom down, what happened?
Mr. Bloom agreed to stick his arm through the boot slot and to be assessed by Rocky. I stood by on the side of it, and as Rocky was putting the blood pressure cuff on, Mr. Bloom pulled his hand back. I had my hand hovering above the boot slot. Just so he was kind of agitated, so I put my hand on top of the boot slot. I was able to treat the blood pressure pump and hose when he pulled it.
So why would you do that with somebody? You said he was agitated, so I did this. What is that link? What is the causal connection between those two things for you?
Just never, with the boot slot open, medical staff touching him. I wanted to just have my hand there in case he tried anything that I could have seen. And I just want to make sure my hand was there in case anything happened. So I just kept it over.
When that happened and he pulled his arm in, what did you do? Or I think you said a little bit about it already, but what did you do in that moment?
I grabbed tried grabbing the whole blood pressure cuff and tried pulling it back out. I was only retrieving the hose and the pump of it. And after that, ended we shut the boot slot and go and try to restart.
All right. Now, when you are discussing where you were standing, can you describe a little bit for the jury where you were standing relative to the cell as best you recall?
Yeah. So it was the cell was one of max. I was far in the hall. Door was here. Boot slot was here. I was standing on the right side of the door. I was right above the seat. Slot my back like to the hallway. So right there.
Officer Tweedle, I'm going to show you what's been marked and admitted as People's Exhibit 1. Here in just a second. Now, after after Mr. Bloom pulled his arm in and the door was shut, were you able to still observe him inside of his cell?
Yes, it was.
What was he doing?
He was swinging the blood pressure cuff that he has still had around and just yelling at us, making us not to come to the cell.
Or do I have permission to publish Exhibit 1 to the jury?
Without objection, yes.
I keep forgetting this is not long enough to go all the way.
Here, once again, blaming the technology and not the operator.
Indeed, Your Honor.
Okay, go ahead.
I am sure it is operator error. It should be ready to go whenever the court is ready. Officer Tweedle, do you see the video on your screen?
Yes, I do.
Can you describe if you see yourself in this video?
Yes, I do. Right closest.
Are we looking at the sort of the back of your body in your right arm? Who's standing to your left?
What's that from?
We needed Nurse Ratchet for this task.
The first.
I'm not even sure why. I didn't even like that person. I guess I shouldn't have said that out loud. What'd you say?
We'll get a name for the record.
I'm comforted it
It
can't
wasn't
possibly,
you,
it
so-
can't possibly be either of us.
Yeah. So, my apologies for the interruption.
Officer Tweedle, can you tell us where you're positioning your arms and your body at this time in the video? It's about the 22, 25, and 52-second mark.
Yeah, so I'm standing a little farther away. We're told not to stick our face or anything close down there. So right now I have my hand above the food slot, stepping a little back, and I think we're talking. Looks like we're talking.
And now where are you?
I position myself closer to the door, closer to the food slot, just in my hand could be closer to it.
And what's happening now?
We shut the food slot, exit the cell, that's when you notify the duty sergeant on the back.
Were you able to observe Rocky's arm being pulled into the food slot?
Oh, no, see it.
What were you paying attention to at that time?
I was more paying attention to his arm.
Who's his?
I'm sorry, Mr. Bloom's arm, focus on the blood pressure cuff, and that was my attention.
Did this happen? How quickly did this happen?
Very few seconds, so I'd say 3 seconds.
Can I have a moment?
You may.
Officer Tweedle, you spoke a little bit about what the
I know there's a temper tantrum, and I'm really curious how it starts.
defendant did after the food door had been shut. Do you recall that testimony? How would you describe the defendant's behavior?
He was very agitated and aggressive, like swinging the blood pressure cuff and threatening us not to come in the cell.
How was he swinging the blood pressure cuff?
He was just like big swings, like at the wall and the door.
So you just made a motion with your body that I want to document for the record. So I'll describe what I think I saw. You tell me if you agree with it. It almost looks sort of as though you were lassoing. You had your arm rotating in a circular motion.
Yes. Lasso's good.
Okay, thank you. I'll pass the witness, Your Honor.
Cross-examination.
Officer, so you were getting Jeff medical attention that day because he stated he felt like he was having a heart attack?
Honestly, I don't know because I haven't seen it, but people were telling me that.
And at first, it seemed like he was going to refuse medical attention, right? I think the word agitation has been thrown out a lot. He wasn't as, calm as he's sitting here today in front of you. Is that right?
Correct.
And you testified that you had like a rapport with Jeff so that you were able to talk with him.
Correct.
And that rapport helped you just kind of like take the temperature down for a moment. And so that the blood pressure cuff was able to be placed on.
Yes.
We saw the video. You guys, you're standing there with Officer Navin and Rocky. You're really close with both of them physically.
Yes.
Probably like a foot from Rocky, maybe like 2 feet from Officer Navin. You spoke about, you did not see Nurse Rocky's hands on the blood pressure cuff, right?
I saw him place it on there, but I did not physically see his hands on it.
So you saw Rocky place it on him, but as far as after that, you did not see his hands on the blood pressure cuff when Jeff pulls his arm back, right?
I do not recall. I was kind of focused on the blood pressure.
Right, you had talked about your hand was hovering over it. And you spoke about being able to grab the hose and the bulb.
Yes.
Even though this all happened pretty fast, you were able to retrieve that as Jeff's arm was going back. You also did not witness Rocky's body hit the cell door, right? We watched the video. You weren't here, but we watched it earlier. That video is from like a side angle of the cell.
Yes.
There's also another camera in the hallway that looks more directly at Jeff's cell.
At the end of the hall, I believe where there's a big window, there's a camera in the top right here facing it from where we looked at it.
That would give us a much better view of what we're talking about, right?
Yes, I don't know what's up right here.
You don't know?
I only video is on right here.
Well, did you check? Okay. I mean, there is an investigation of an alleged crime here. Did anyone check that video?
Objection, speculation.
Well, I'll withdraw. Officer, did you check that video?
Objection, asked and answered.
Sustained.
Do you have any personal knowledge of anyone checking if there was other video?
No, I was not at the review of the video. It's usually starts.
So your superiors would have access to whether that video is working? And the video that we have, you don't really see a whole lot in the video, right? I mean, look, it's fair to say that we don't see it happening in the video.
Yes,
We don't see Jeff pulling his arm back. We don't see what's going on.
You may step down, sir.
Excuse.
Any objection?
There you are.
This witness is excused. Thank you, sir.
Here, the people rest.
All right. May we then take the jury? May be seated. Are there going to be any witnesses for the defense?
I was hoping the court would indulge me a couple of moments to speak with Mr. Bloom about what is this that call?
All right, very good. Then we'll take him back. And how much time do you think you need?
Would the court indulge me at least like 10 minutes?
All right, well, why don't we do it this way? We'll take him back and then we'll reconvene at 2 o'clock.
Thank you so much.
Thank you. For the being recess.
The District Court for County of Washington, State of Michigan is now back in session. Judge Jason.
You may be seated. Let's get him out.
Oh yes, I edited all of this. You're welcome.
Rest.
Back on
Watch
the
out,
record in the
Glasgow's on
case
my
of
list.
the people versus Jeffrey Wayne. Counsel, state your appearances, please.
Somebody for people.
Good afternoon, Your Honor. Sam Bernstein with on behalf of Mr. Bloom. Still here with.
All right. Are there going to be any witnesses for the defense?
I'm not going to call any witnesses, Your Honor.
All right. Mr. Bloom, you understand that you have an absolute and constitutional right to testify?
Yes, sir.
You understand that that decision as to whether or not you testify or not is your decision we made in consultation with your attorney. You understand that? Is that a yes?
Sir.
And you also have had an adequate opportunity, you believe, to discuss that, as to discuss whether or not you should testify with your attorney.
Yes, sir.
And taking all of that into consideration, sir, is it your determination or your decision that you do not wish to testify in this matter?
Yes, sir.
Thank you. All right. Counsel, then after, when the jury comes out, after the defense rests, then we'll go right into closings if the parties are prepared to do so.
Yes, Your Honor.
Yes, Your Honor.
All right, and then I would presume to then give instructions there.
Nice work by the attorney because you know he wanted to testify. Nice work by him because that would not have helped his cause. And he's actually kind of got a plausible defense going here.
Immediately thereafter, and I'll go through them by number and then ask you whether or not you wish any additional instruction. Court's intending on giving 3.1, 3.2, 2.4 regarding the elements of the charge along with the elements, 3.3, defendant not testifying. 3.5, evidence. 3.6, witnesses credibility. 3.10, in terms of time and place. 3.13, possible penalty. 3.15, exhibits. 3.16, written instructions in the jury room. 4.1, I think is appropriate, although there are not, those are statements as evidence against defendant, statements as evidence against defendant. There were certain statements that were made that could be viewed as the defendant's statement as evidence against him. 4.3, circumstantial evidence. Don't think there was any impeachment. There was actually prior consistent statements, but 4.5 I don't think is appropriate under these circumstances. I did not take judicial notice of it. 4.6. That was either party requesting 4.9. In
I
terms,
have requested it.
you, any objection to 4.9? Motive?
I think she can request it and get it. I don't know that it's necessary.
I think that given the defense counsel's opening statement, motive is a question that's properly, I think the motive jury instruction would be properly before the jury to explain that motive need not be proven by the people.
Intent, 4.16. I will give the motive instruction. 4.16, intent. 5.2. Well, actually, 5.2 would not be appropriate because there's not conflicting evidence. 3. .11 is a bit more problematic from the court standpoint. These are technically not police witnesses. However, they are law enforcement. So.
And it's my understanding they're not sworn law enforcement officers.
Correct.
They're corrections officers. But I do believe I would request 5.11 just for the sake of, because they do work in corrections, that distinction may be somewhat less important to a person who's not constantly involved with police and understanding the distinctions between those different departments.
I agree with that reason, Your Honor. That would be my request.
All right. I would only change that I would make to the standard instruction is I would be using the term correctional officers as opposed to police officers, unless there's an objection to that.
No, thank you.
17.2, just battery, then definite. So 17.2, 17.14, 1.5, 17.16, then 13.11, and one more, which is 13.14. Those are all the ones that the court has, with any additional ones that were requested by any of the parties.
13.12 or 13.11?
What, oh, what I said, you mean?
Yes.
I said 13.11, jury deliberations at verdict.
And then the last one that you said was?
Was 13.14, or 3.14, I'm sorry.
3.14, those are the two that I highlighted on my list. Okay. Thank you, Your Honor.
So wait, 3.11, Your Honor?
3.11.
Okay.
And then 3.14. I'm sorry, I was saying those numbers.
13.11.
Yeah, no, I did say 13.11. You're right. All right.
Those sound good to you, people, Your Honor.
All right. I think what I'll do is I'm gonna move. Just so that we have it all correctly. Did not testify. Just gonna That maybe to make more sense. And council. Looks, but I'll do it this way. Show you the proposed verdict form. I'm gonna ask whether or not you have any objection to the verdict form.
Thank you.
Any objection from the
No,
people?
Your Honor. Thank you.
Any objection from the defense?
No, Your Honor.
All right, thank you. There was exhibit, oh, go ahead, I'm sorry.
Was there like something on the back of one of them?
I made a clean copy of Exhibit 3 during a break, Your Honor, so now it only contains the front and there is no back.
Awesome, thank you.
And I have I have a copy of the exhibit.
Entire exhibit packet.
The disc contains 3 videos. We only watched the first one. So if the jury wants to watch it back, there's proprietary video technology, so we'll probably have to come back in the court and play it again.
Got it.
It's only the first video on that disc.
Could I ask, Ms. Lundy, was that email, was that published already to the jury?
No.
It was not because of the back copy.
People are ready.
Mr. Grisham?
Oh, yes, Your Honor.
All right.
There shall not be any cutting of trees. Don't cut any trees. I'll pass the order to them. No cutting of trees, no felling of trees in Patna number 12.
Jury is present.
Thank you. People having rested, any witnesses for the defense?
No, Your Honor, thank you.
All right, very good. Parties prepared for closing argument?
People are prepared.
You may proceed.
May I move the lectern?
Let's do this.
Depends on where you want to put it, but yes, you may go.
Both need it very.
That's all right. That's
Thank you. Good afternoon. When we started this morning, I let everyone know what I expected the evidence would show. Started talking about that Rocky Isley was a nurse working in the jail, and on that date, the defendant was incarcerated in the jail. Talked about how we were going to hear from different witnesses about the defendant reporting to experience a medical emergency. We've heard from 3 different witnesses. First, from Officer Naveen, talked about how that was his assignment that day. The defendant had been upset that day. He talked about how he was upset even earlier in the day. He understood that the defendant was upset about something that had happened before Officer Naveen had even gotten there that day. We heard that he cannot ignore anyone's request for a medical emergency. Because Officer Naveen and Officer Tweedale and Nurse Rocky Isley have a responsibility to make sure that the people in the jail are safe. That's their job. The corrections officers are there to make sure that the folks who are in the jail are okay. They don't make the decisions about who goes there. They don't make the decisions about who leaves. Their responsibility is safety. Officer Naveen is talking about how he checks every 15 minutes, make sure the people that are in his cell block are okay. He talks about how he makes sure Mr. Bloom is okay. Nurse Rocky tells you about how it's his responsibility when someone says they're experiencing a medical emergency. He doesn't care how old they are. He doesn't think something's more or less likely based on their age. He doesn't think something's more or less likely based on who they are. He is there to make sure they are okay. Officer Tweedale is the one who speaks to the defendant and says to him and gets him to calm down enough to be medically evaluated. Why? Because it's his job. That's his job. He's got to find a way to communicate with each person to help them. Nurse Rocky, I'm sure everyone has experienced a nurse who made you feel safe, who made you feel cared for and listened to. And Officer Tweedale, when this is going to go down and he knows that Mr. Bloom has been upset, and he knows that Mr. Bloom has been agitated. He told you how he levels his hand above the food slot door just in case. Why would you do that? Just in case. Safe. But the only person out of these 4 men who didn't care about the safety of another person was the defendant. You're going to get jury instructions in a few minutes that display for you and educate you that the law does not allow sympathy nor prejudice to influence when you are making this decision. You should not be prejudiced against the defendant because he was incarcerated, nor should you be sympathetic to him because he was incarcerated. The law requires an examination of the facts. And the facts are simple. The facts are the defendant was in the jail in Washtenaw County. The facts are that the defendant said he was having a medical emergency. The facts are that earlier in that day, he'd been very upset. He was not allowed to get out of his cell. The facts are that he was a level 1 security. The facts are that he had to be medically evaluated through his food slot. And the facts are that when he was being medically evaluated, he yanked his arm back in that food slot, and that slammed Rocky Isley into his wall, or into his door, rather. Now, I can't tell you what defense argument there might be, but I will tell you that you've seen a video, not my favorite angle. You've seen medical records, and you've got a copy of Rocky Isley's own statement that he made on May 31, the day after this happened in the night, about what happened. Everyone has a right to be safe at work. Everyone has a right to be safe at homes. All of the witnesses that you've heard from today helped to keep the defendant safe at his home. His home he didn't choose. He didn't choose to be in the jail, but that's where he was. Each of those men told you how they made a choice to keep him safe, despite his behavior, despite his influence.
Stop for a moment.
I'm sorry,
I apologize. Mr. Take the jury, please.
I'm so sorry, Your Honor.
No, it's not you. It's not you. Take the jury, please. Ms. Lundy, everybody may be seated. And
It's getting hot in here.
I apologize for interrupting you in the middle of closing.
I'm terribly.
The behavior from him from Mr. Bloom, I am not going to have in terms of his gestures, his noise and everything, particularly behind Ms. Lundy's back. Not gonna have it. Mr. Burnton, I'm gonna give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all before I continue. Take him back. Court is standing in recess.
All right.
The United District Court of County, Washington State of Michigan is now back to the Judge Day 17.
You may be seated. And if we can bring Mr. Bloom up, please.
Okay, does he come back? Oh, there he is. Big dummy, let's go.
Court recalls the case of the People versus Jeffrey Bloom.
Absolutely, for people.
Good afternoon, Mayor Sam Bernstein with and on behalf of Mr. Bloom.
And as I've apprised counsel, during the course of the trial, Mr. Bloom, I don't know, and I'm going to assume that at least for these purposes that you weren't doing it intentionally. There have been comments which I could hear all the way up here, and I'm sure the jury could hear it during the course of these proceedings. That then, when Ms. Lundy got up to give her closing argument, there were additional comments. I didn't do anything about that, but the moment the gyrations with your hands occurred behind her back, I stopped the proceeding. I'm not going to tolerate any of that. I will stop it again if that's what we have to do, but I'm going to admonish you and warn you at this time that the court is not going to allow that type of conduct to occur. With that admonition, Mr. Bernstein.
I was going to say there were some times where Jeff was speaking with me during the trial.
Oh, I understand that, but there were other points at which there were just extraneous comments. So I was letting those go, but I'm not going to have that and have counsel interrupted during the course of their closing arguments. With that admonition, are the parties ready for the jury?
Your Honor, I also understand there's been information given to the jury that.
Correct. Yes, for the purposes of the record, I did inform counsel. So at no, that the jury did not take that in any way to be applicable either to Mr. Bloom or to the people, because I had stopped Ms. Lundy in the middle of her closing argument. And I had indicated that they are not to take any delay or interruption by the court. They are not to attribute it to either party. They are to attribute it to the court of its own doing, so that the jury understands that and does not hold that against the people or against the defendant.
Thank you, Your Honor. I am ready to proceed.
Is the defense ready?
I am ready, Your Honor.
All right, let's bring the jury. What is going on? All right. Go ahead. Thank you.
Still hot mic.
Oh.
We're, is he ready to, what's? Pardon?
I don't think he wants.
Sick, Your Honor.
No.
Yeah. Did you want to go back there and try to talk with him? Because in the record should reflect, if it doesn't already, that after the court's admonishment to defendant and asking whether or not the people in defense were ready, that the defendant on his own accord decided that he would leave the courtroom. I've been informed by transport that it appears that he does not wish to come back out.
I really should try to speak with him, Your Honor. I mean,
Yes, you should.
it's a significant right to be at your own, like in the Constitution or something.
One which one can, I believe, voluntarily forfeit.
That's fair too. Yeah.
So before we get to that stage, why don't I'll stand in recess and allow you to have an opportunity to chat. All right, thank you.
All right.
Ladies and gentlemen.
Okay, like in the Constitution or something was funny.
Yeah, Alan's trying to put the jury out. So. All right. Okay, we're back on the record. Court does recall the case of the people of the state of Michigan versus Jeffrey Blum. Counsel, state your appearances.
Ashley Lonnie for the people.
Sam Bernstein for Mr. Bloom, Your Honor.
All right, Mr. Bloom is not present. If I say anything incorrectly, please, counsel, correct me. Just prior to our last recess, when we were trying to continue with the trial, after the people had begun their closing argument, I stopped the proceedings, gave an admonishment, had the jury removed, gave an admonishment to the defendant regarding comments that he was making, as well as gestures in terms of his hands because of the positioning of the podium behind the prosecutor's back. Gave him that admonishment, then told him that I would not tolerate any of that behavior. At that point, I did not hear anything, or at least nothing that was audible or understandable from the court in terms of the defendant saying anything. The defendant got up and he removed himself from the courtroom. Transport took him back. I took a recess in order to allow Mr. Bernstein to speak with his client. I was then informed during the course of that from transport that Mr. Bloom did not wish to return to the courtroom. And so that's kind of where we were left. The question that arose as to whether or not this court, given the defendant's behavior, whether or not this court could continue with the trial, even though we just had closings and the verdict to go. Out of an abundance of caution, after speaking with counsel and the court looking up for some guidance in this regard, the court did find me, I think it's Rule 43, I didn't bring my copy out of the federal rules, which specifically address the issue where a defendant removes himself from a trial in the middle of the proceedings or doesn't elect to participate. I did not see a rule specifically in the Michigan court rules governing that. As I did a brief research and trying to find cases, the case of the people of the state of Michigan versus Jerry Oliver Swan, that being 394 Mich 451, came to light. It was a 1975 case, so it's a little bit old, but it still looks to be good case law. I gave that to council, asked them to take a look, see if we could, between all of us, make a determination as to what would be the best way to proceed. And granted, I don't think anybody's had an opportunity to do any extensive research on it. However, I would indicate that if nothing else, the Swan case is less illustrative of a point. And the synopsis basically indicates the Supreme Court held the defendant did not reappear in the courtroom after a mid-trial recess, had not reappeared 4 days later, and testimony was received regarding attempts to locate him. Trial court properly proceeded with the trial with receiving, part of the testimony in the jury's verdict in the defendant's absence. Taking that without anything else in front of me is sort of a guideline. The court believes that the defendant has conducted himself in a fashion where he has made himself absent mid-trial. It seems to me that what the Swan case seems to point to is that an opportunity be given where this defendant being in custody, we don't have to locate him, but at least an opportunity to be given to the defendant to come back and voluntarily participate in his trial.
Please.
Having said,
you've got to be kidding me. I love Judge Simpson, but just finish the damn trial. He walked out voluntarily. He's represented by counsel, had a chance to talk to him. Finish the argument, get a verdict. One way or the other.
All of that. After speaking with counsel, the court has made a determination to adjourn the remainder of the jury trial. We are adjourning it to September 30th, 2024 at 10 a.m. For closing arguments and final instructions to the jury.
Fantastic. All right, defendants in Michigan, you can just walk out of your trial and get yourself a free continuance anytime you feel like it.
During that week period in time, in essence, the court is giving an opportunity for the defendant to reconsider his decision. Also to allow his counsel to potentially have a conversation with the defendant as to what may be the implications of him having removed himself from the proceedings. But I think in fairness, and since they are monumental and rights that the defendant would be forsaking in terms of
it's time.
Leaving his trial, the court thinks that it would be prudent for the court to do so. That was long.
Which is number one, wrong.
Either counsel have anything to add or to say contrary to what the court has indicated on the record?
I do.
Nothing contrary, Your Honor.
Neither for me, Your Honor.
All right. Very good. And I do appreciate both counsel.
What are you going to do? You got 7 jurors in the box. You're going to drag them back another day? Are you kidding me? The jurors won't show up. You're going to get a mistrial.
Being patient as the court was trying to think through this and also participating in trying to find something that would guide us. It was really truly appreciated on this court's behalf. So this matter is adjourned to September 30th, 2024, 10 a.m. for continuation of the jury trial. Thank you.
Thank you, Your Honor.
I've never seen that before.
Don't go off yet. I should also know one other thing. The people had requested that I give to the jury an instruction to not talk to anybody, same instruction that I had given them during the opening statement. but just to reiterate that to them. And the initial thought was to bring them back out, give them that instruction, and then have them go. And I think it was correctly pointed out that Mr. Bloom not being present here may send some signal to the jury. I assured counsel after they had indicated that they trusted the court to give that instruction to the jury. I did do so. They each acknowledged that they understood that instruction before leaving. So
Thank you, Audra. That's accurate. People wanted to be sure that they very understand that those, not talking to people and all those risks do continue during this adjournment. I appreciate that. Thank you.
yeah, thank you, folks. I think that's it. 14A stands adjourned.
I don't know. I'm not familiar with the case. It's a Michigan case. Although what he read of the holding seems to confirm my position. Continue to the end of the trial. You got about another 20 minutes of argument, and then you read jury instructions and go. Now you're trying to, yeah, or exactly. You have him in custody, drag him back out. I'm going the other way. I'm thinking, okay, I know. Meanwhile, he's got an okay defense in the case. He could be convicted. He could get not guilty on this real easy based on the facts. I thought the nurse made a decent witness and made the case if you want to go that way. But you could also just say that he didn't intend to do that to the guy. He was just pulling his arm back. You can say, we believe the nurse, but it still isn't enough for this charge. And you've got a high burden beyond a reasonable doubt. I would be more inclined to hold him in contempt again for his antics during the trial than to continue his freaking case, burden 7 jurors with coming back. I don't see where this is required. I have not researched the issue. I've never seen anything like that. I've never seen that in my entire career. Never. I've been involved with cases that go for a while and then there's like a holiday in the middle, so we skip a day or some strange thing like that. But basically, once a jury trial starts, 99% of the time, in my experience, that thing goes every business day till it's done. And that's that. Whatever. Judge Simpson, I think he's a smart guy, a good judge. I really do. I don't agree with this particular call, which isn't the end of the world. It's not that crazy. He sets it over another day. I just think you got real problems getting these jurors back, and you're also disrupting the whole vibe. And what do you do with the prosecutor? She's going to start the argument over again. And if she starts the argument over again, then does the defense say it's cumulative? I can't begin to tell you the number of issues you're inviting with this continuance. All right, nobody really cares. I'll stop talking. Nobody cares what I think. We did get some yeah, seriously. Seriously, maybe they should have just wheeled him in. Maybe they should just put him in the restraint chair. And then this wouldn't happen. It's not the end of the world. They're handling it that way, but it blows my mind. That's not what I expected. I wanted to see the fireworks with Bloom, but I can't believe that the day ended that way. You're halfway through the prosecution argument, and the guy walks out. Okay, go sit in your cell. We're gonna finish this thing. We'll tell you what happens. You voluntarily left. A 10-minute continuance so that the attorney can go talk to him once, sure, absolutely. But we did that. We already did that. I don't know. I could be wrong. I think he has other charges too. I'm not even sure because I can never keep up. There's so many. He has so many cases, and there's so many of these goofs that do so many things that I can't keep them straight. They're not actually on my docket, so I don't have to worry about it. But I'm not sure. Maybe it's just maybe he's got like 5 other pending things, and he's not getting out of custody no matter what. But I mean, even for the defendant, you want to get a verdict. Maybe they're going to come back with a not guilty and let him go. But certainly for the jurors. You got 7 people who have to come back to court for this? Oh my God, I'd ring them up. If I was on that jury, I would go for the death penalty. You made me come back? You made me come back to the freaking Washtenaw County Courthouse? You're going up the river, my friend. And that's that. All right. Nobody needs my rants now. I'm just surprised at the end. That's all. I'm surprised. Thank y'all for coming out. I appreciate it. I'll see y'all soon.